thank you to CVAR for letting me come here today. I'd like to start with a quick stretch. Everybody raise your left hand. Everybody raise your right hand. Put your right hand down, left hand down. I now know all of you can raise your hands because I will be asking questions through this and I expect people to participate, okay? Gentle lady getting herself some coffee right now. Can you hear me? Yes. You can hear me? And you can hear me back in the back? Okay, I just want to make sure everybody can hear me without a mic. So that's not going to be a problem either. So I am Kent Meyers. I'm a property tax specialist. I've got 17 years working for the Ventura County Assessor's Office. I became a property tax agent about 8 years ago. I worked for a firm for about 5 years, and I went out on my own about 3 years ago. My business cards are on the back desk over by the registration. I see one person picked one up, so I won't get very many phone calls after this today. But if you want one of my business cards, they're right there in the back. So, how many of you own property in Ventura County, San Francisco County, Sierra, Placer? Okay, we're in the hotbed right now of the assessment appeals period. July 2nd is the open period to file a property tax appeal. In the counties that I just mentioned, plus another 6 or 7 of them, you cannot file after September 15th. The other 47 counties, you have until November 30th to file your appeal. This year is December 2nd because of the weekend. But you have to file a property tax appeal no later than November 30th of this year, or any given year, on those 47 counties. Now, property tax appeal, you can file an appeal on several things. As realtors, most of you are aware that when there's a change of ownership on property, the property gets reassessed to current market value. So how many of you have heard this before? The assessor will enroll the value that you paid for the house as your base value for property tax purposes. Only one person has heard that. Okay, 2. That's not true. They will enroll the fair market value. The presumption is your purchase price is fair market value. But if they determine, for any reason whatsoever, based on comparable sales, that you might not have paid fair market value, they can enroll a different value. So they can go ahead and say, okay, this person, I'll give you an actual example from when I first started with the assessor back in 1999. I had a sale come across my desk. Granted, this is 25 years ago. Values were a lot lower. The average home in the neighborhood was going for about $425,000, and this house sold for $325,000. Same size as all the others, but for some reason it sold for $100,000 less. That's a big percentage difference. I called the owner, asked him how come he paid so low. He asked me who I was, and I explained what I was doing. And he said, well, maybe I should call my attorney. And I said, well, you have every right to call your attorney, but I have an obligation to enroll fair market value. If you can't tell me why you paid $100,000 less than all your neighbors, then I'm going to enroll what I consider fair market value. We got off the phone. I enrolled $425,000 as his market value. And as soon as he got the notice, he gave me a call. He said, well, my realtor wouldn't even go inside the house. There was a lot of destruction inside the house. There was a lot of damage to the house. There were rodents in the house, and she wouldn't even go in. So send me your documentation. Show me some photos. This is, again, 25 years ago. Ventura County at that time, I'm not sure what they're doing now because it's been 8 years, did not have access to the MLS, and the MLS was not as active on the internet as it is today. So I couldn't look up photos myself. I couldn't look up the listings myself. So he had to get the documentation for me. Once he gave me all his documentation for cost to repair and some photos of what it looked like on the inside and the listing, I went ahead and accepted his sales price. But the assessor's not required to accept the sales price. They are required to enroll fair market value. The presumption is that the sales price is fair market value, and they have to have evidence to enroll something else. So they're not required to enroll the purchase price. What sort of things can you appeal? You can appeal your value if the assessor does not accept your purchase price. You can go ahead and appeal the value if they do accept your purchase price. I've just picked up a client this month. San Francisco had to file the appeal no later than this past Monday. He called me last Thursday. He paid $2 million for his home back in 2020. It was August 2020, bought the home for $2 million, did a home inspection. They estimated about $36,000 worth of termite damage. Once he closed escrow, they started working on the termite damage, over 6 figures to repair it. They had to tear outside wall off to get to it. He wants me to try to reduce his value by about $150,000 to $200,000. I'm going to make the attempt. But it's harder to get a reduction off of a fair market value that gets enrolled by the assessor than it is to get your value challenged if they don't accept your purchase price. Because now you had the burden of proving that you paid over fair market value. So that's what I'm going to be working with him, and it's due to damage on the property that he was not aware of before he closed escrow. He knew about part of it, but not all of it. I had a customer in Beverly Hills. They paid $5 million for a home. And first thing that somebody does when they buy their $5-6 million homes is they remodel. They get the kitchen to look the way they want it to be. They change out the flooring. They remodel the bathrooms. It's very typical, right? You've seen that sort of thing on all the $10 million sales that you guys have had? Okay. That's the first thing that people do. But even on the smaller sales, one of the first things that people do is repaint, remove the flooring. Flooring isn't worth much. I've seen places that are people that sell a home, put brand new flooring in, and then as soon as they close escrow, the people that move in rip out the flooring, put something they like better. But when this guy who paid $5 million for his home in Beverly Hills just started doing his remodel, they opened up some of the walls in the kitchen and found some structure issues with some remodels that had taken place before them. Didn't know who did it. They were like the 4th or 5th owners, so they couldn't point their finger at any prior owner, so they just had to suck it up and try to fix it. We actually got his base value reduced to $4.1 million. So that's a savings of about $11,000 a year in property taxes. I call that a win, because he was challenging his base value on something that was listed on the open market. He remodeled his home after he bought it and found damage that he was not aware of. You guys have all dealt with home inspectors before? How often does the home inspector go in there and tear open a wall to see what's behind it? Never. So there's surprises, and that's what you're going to deal with. So that's one of the other things you can file an appeal on, your base value, either because you paid too much or because the assessor did not enroll the purchase price. New construction. When you do any kind of new construction on your property, the assessor is required to reassess the property for that new construction. That doesn't mean they reassess your entire property. An example would be you own a home and you decide you want to expand it by 300 square feet. Do a little tiny addition. That 300 square foot addition is all the assessor can pick up. They cannot revalue your land. They cannot revalue the original structure. They can only add value for that new construction. So if you pick up a 300 square foot addition, they try to pick up the value of that. Normally it's going to be cost, but if they have evidence based on paired sales analysis, they can pick up what the market recognizes on that new construction. Swimming pools, accessory dwelling units or ADUs, granny flats, second garage, any of that is called new construction, and you get a reassessment for that new construction only. And you can appeal that value. Now on the base value and new construction value, because the new construction gets its own base value, you have 4 years after the July 1st to file an appeal. So I was mentioning the guy in San Francisco, he bought his home in August of 2020. We just filed on his base value this year. It's the last year that he can file on his base value. If he waited till next year, it's over with. but it's prospective only, meaning he doesn't get any tax refunds for the prior 3 years because he didn't file on those years. It becomes prospective with 2024, and his tax base can go down in the future, but not in the past. Other things you can appeal, your current market value. I don't know how many of you were selling property back in 2005, 6, 7, 8. What happened after 2007? Market took a dive. They call it decline in value. The assessor is not allowed to enroll a value higher than what you can sell the property for, effective January 1st of each year. So you guys are going to be getting your tax bills next month. That value on the tax roll is going to reflect the value as of January 1, 2024. So it's already 10 months behind. Or your base value, whichever is lower. So let's say you bought a home in, let's say, 2010 for $1 million. Every year it goes up 2% maximum. So 14 years ago, you're looking at about 30% increase compounded. So you're looking at about $1.3 million, but it might be worth 2.6. You don't have a case. But if they're enrolling 1.3 million, but you can't sell it for more than 1.1 million, you can file an appeal to try to get that value reduced by $200,000. The difference is, on a base value appeal, where you're trying to appeal the sales price or new construction value, that's a permanent reduction. A decline in value is a 1-year reduction, 1 year only. And when you file that appeal and the board hears you or the assessor stipulates with you on a lower value, the assessor becomes obligated to review your property value annually until it gets back to the old base value. So your base value will increase by maximum 2% per year. But if you go on to a decline in value, there is no percentage that the assessor can raise it, provided they don't go above your base value. Example, let's say you paid $1 million and it goes up 2% per year and you're up to, let's say, $1.3 million. Market value drops down to $900,000. That's a $400,000 difference, about a third of the value, 33%. And the very next year, the market value goes back up above 1.3. The assessor can bring it back up to that 1.3 million. And that's a 33% increase year over year. But they can't bring it above the base value with all those 2% per year. Does that make sense? Okay. Other things that you can challenge the assessor on is a change of ownership. I do a lot of that. So an example of a change in ownership is when, what you guys are most familiar with, you put a property on the market, somebody comes by, they buy the property, record the deed, the assessor reassesses the property. Change of ownership. But if you take your property and transfer it into your trust, as long as it's just you and or your spouse that are the trustees of the property and trustors of the property, there should not be a reassessment. If there is, you can challenge them. Most counties, I'll back up just a little bit, 90 to 95% of my clients are in LA County. LA County is like the largest county in the country, let alone the state. 25% of the people in California live in LA County. There's 1,500 employees in the assessor's office of LA County. I was in Ventura County, 125 employees. And Ventura County is like the 8th largest county in the state. LA, number 1. 1,500 employees, it's where you have the most value and where you make the most mistakes. Every assessor's office makes mistakes, but not on the scale that LA County does. So that's why 90 to 95% of my clients are in LA County. So at any rate, if they ask for a copy of your trust and you don't provide it, they're going to reassess you. And in LA County and their ownership crew, once they make a decision, it's final, and they'll expect you to go ahead and file an appeal. Orange County, Ventura County, Santa Barbara County, they're much more lenient. They'll take the time to talk to you. I deal with them all the time. I deal with LA all the time, but LA is harder to deal with. So
okay, when they want the trust, do they only want the part of the trust that has the actual property on it, or do you need to give them the full trust?
they want the front page, the back page, and everything in between. So, yeah.
Two questions. What about San Bernardino County? How do they work? And
I have very few clients in San Bernardino County, and I've had different feelings about San Bernardino. Sometimes they work with me well, sometimes they don't. And really, that happens in every county. There are certain people in LA County that I can work with quite well, but the majority of them, they're just doing their widgets and just want to move on. But San Bernardino County, I've had good and bad experiences.
second question, what happens when someone inherits the property through a trust?
Okay, you're getting into Prop 19. You want a real question, huh? Okay, so I'll get to that in a minute because that's going to be a long topic. Change of ownership issues also. I've got a client right now. Property was held in the name of their mother and their cousins. Their cousins inherited from their parents years and years ago. Their parent died in 2017. And you guys are familiar with parent-child exclusions? Okay. Prior to Prop 19, a parent-child exclusion, you would not be reassessed on the parent's primary residence, plus up to $1 million of assessed value on other property. In other words, let's say you had a shopping center that you bought 40 years ago for $300,000. A lot of money 40 years ago. And it's now worth about $6 million, but the assessment would be $600,000. That would have qualified for the parent-child exclusion because the assessment was less than $1 million. Plus you could get other property in there up to $400,000 more. Well, their property was, well, they inherited a lot of property, I'll just say that, and it wouldn't qualify for parent-child exclusion because of the overall assessed values. Their tax base jumped $300,000 a year. I mean, their actual taxes. That's a $30 million increase in value on owning 50% of the property. It's not a cheap property. It's an office building. But there is a clause in the Revenue and Taxation Code regarding legal entities and partnerships. They have an underlying partnership, even though the property was in the names of themselves. They had an underlying partnership agreement which made it owned by a legal entity. Legal entity laws are different than typical tenants in common or married couples that own property. If you have a partnership agreement underlying it and you bought the property in a partnership or legal entity, it only gets reassessed if there's a change in control. A change in control means one individual has more than 50% interest. So you had a situation where siblings had owned the property, it transferred to, in a partnership, but on title in themselves, transferred to their spouses when they died, nobody has a controlling interest, and subsequently transferred to their respective children when the spouse died. So you got two kids over here that own 50% combined, and two kids over here that own 50% combined. They did a 50% reassessment, $300,000 in tax bills, and they ran it late. So it was $1.2 million in tax bills that I'm going to get canceled and completely erased from the books because it's technically a legal entity. You know about split rolls where they tried to get commercial property reassessed off of Prop 13 and get it every 3 years get reassessed? It's because of situations like that where shopping centers that own property in a legal entity do not get reassessed unless there's a change in control. Best example, everybody know who Michael Dell is? Nobody knows who Michael Dell is. Anybody own a computer? Anybody own a Dell computer? Okay, there you go. So Michael Dell, the founder of Dell Computers, wanted to buy a hotel down in the Santa Monica area a few years back, about 10 years ago. He was in the process of purchasing. He was going to buy it for $135 million. That's about $1.5 million a year in property taxes. Okay. He got his attorneys involved, and the attorneys looked it up and found out that the hotel was owned by a legal entity, and that legal entity had bought the hotel. So their assessment was about $95 million, which makes it about $1 million a year in property taxes. So $500,000 less per year. So they arranged for Michael Dell and his wife to buy the LLC that owned the hotel through various trusts, so that Michael Dell owned half and his wife owned half. So if you own property community, it's considered spousal 50-50, even though you're both on title as tenants in common. Well, that's what they did with this legal entity. So there was not a controlling interest. Michael Dell owned half, his wife owned half. Kept the assessment at the $95 million, saved them $500,000 a year in property taxes. Well, the problem is when lawyers and realtors, CPAs get involved with big deals like this, they like to brag about it in their trade magazines. And the assessor's offices look at these trade magazines. LA County's going through the trade magazine. Whoa! Michael Dell just bought a hotel for $134 million or $135 million. Call them up and say, hey, send us the documents. So they went through the LLC documents, and right after they purchased the hotel, or I should say the LLC that owned the hotel, Michael Dell's wife transferred her 50% over to Michael Dell. So Michael Dell was the sole owner. Also, with legal entities, interspousal transfers are not considered changes of control or changes of ownership. So within that, he could gain 100% through his wife because it's interspousal and non-reassessable. LA County said, oh, no, that was just a step transaction. The assessor has the right to collapse step transactions. So they went ahead and reassessed them at full market value, the $135 million, sent out these new tax bills, and they got challenged. They argued in front of the Assessment Appeals Board and said, that's too good to be true. It was a step transaction. You can't do it. That was their whole plan from the very beginning. We're done. The Assessment Appeals Board agreed with the assessor. The attorneys took it to Superior Court. I'm going to stop right there. I am not an attorney. I can't take the assessor to Superior Court. I can go to the Assessment Appeals Board, but if you don't like the outcome and you want to go to Superior Court, you have to hire a real attorney. Took him to Superior Court. Superior Court overturned the Assessment Appeals Board. The assessor then challenged that at the higher court level, i.e. the appellate court level, and the appellate court level said, no, the Superior Court was right, the Assessment Appeals Board was wrong, and the assessor should never have made that argument in the first place, saving him $500,000 a year in property taxes. So that's why you'll see on the ballots about every 3 years these split roll things where they want to try to get commercial property reassessed every 3 years at fair market value. But that's just one of the things that they do. So you brought up the question about parent-child exclusions and the trust situation. I've got a lot of those going on. Okay. A trust. How many of you people own property? Okay. How many of you hold title in your trust? Most of you. Married? So you and your wife, community property. Most trusts are worded so that the surviving spouse will get a life estate in the property. Once that happens, there's no reassessment upon the first death. When the second owner of the property dies and is held in trust, the trust becomes irrevocable. Revenue and Taxation Code says that when a trust becomes irrevocable, the property is reassessable unless there's an exclusion that applies. In a marital trust, a lot of them are written to where that life estate is created, but half that trust is now irrevocable. because the life estate is created for the spouse, there should not be a reassessment, even though half of the trust is irrevocable. Once it becomes 100% irrevocable, the beneficiaries of the trust are now the owners of the property, and the property is supposed to be reassessed. Change of ownership statement, death of real property owner, whether it's in the name of the trust or not. 150 days to file that after the property owner dies. So that's the trustee responsibility to file that change of ownership statement, death of real property owner, upon the death of a trustor. Okay? You're shaking your head. Is that because you're confused or because you just didn't know that?
Didn't know that.
Okay. Okay. So the children immediately become the new owners of the property, or whoever the beneficiaries, but we're going to stick with, in most cases, it's children. Yes, sir.
Yes, sir. What if,
You look familiar. Have you heard me speak before?
I've been in this business about 40 years.
Okay.
I have properties in several counties. My concern is, what if I have four of my kids as joint tenancies in that trust, and I pass on, and this wouldn't the joint tenancy keep the taxes the way they are?
It depends.
That was my plan.
Okay, well, let me get to that. Let's finish this part. But it's a good question because it depends. So once that trust becomes irrevocable, the beneficiaries of the trust are the owners of the property, and it's 100% reassessable. So in most cases, what you own is a single family home. And most people only own the home that they live in. There's not a lot of people that own a big hotel out in Santa Monica, okay? And they keep it in their trust so that everybody knows where it's going to go when they die, and how it's supposed to be divided, and you don't have to pay for probate, which can take about 8% of the estate. So I advise people to use a trust whenever possible. But it's reassessable as of the date of death of the second owner, and you could qualify for the parent-child exclusion if and only if a child moves into the house within 1 year after the second death. If they don't move in within 1 year, they will not qualify for the parent-child exclusion. Second, they must file a homeowner's exemption within 1 year. If they don't file the homeowner's exemption within 1 year, they can still get the parent-child exclusion, but it becomes prospective with the first year that they file the homeowner's exemption. So let's assume for a moment parent died in 2022. The kid moved in a month later, but they just filed the homeowner's exemption this week. They'll get their 2024 taxes corrected, but they're not going to get refunds on 2023, and they're not going to get refunds on their supplementals. Everybody here knows what a supplemental is? Raise your hand if you know. Okay, raise your hand if you don't know what a supplemental is. Okay, only one person raised their hand saying they didn't know, but about a dozen of you didn't raise your hand when you said you did know. Okay, so supplemental, as of the date of a change of ownership, it's in the middle of a fiscal year, because January 1st is considered the first of the year, but July 1st is the beginning of a fiscal year. The assessor has to take all recorded documents between January 1st and December 31st, determine what the new value is based on those recorded documents as of January 1st of the upcoming year, and make sure that it's on the roll by June 30th, the end of the fiscal year. If you purchase a property between January 1st and June 30th, you will get what's called a supplemental bill for the period of the fiscal year from, let's say you bought in April, from April through June 30th of that fiscal year. So if somebody were to buy April of this year, April 2024, they're going to get a supplemental bill for the 23-24 fiscal year and the 24-25 fiscal year. If they buy a property today, September, they'll only get a supplemental bill for the 24-25 fiscal year because the 24-25 fiscal year is closed. They've already enrolled the value for 2024, and you're going to get your tax bill next month for your 2024 value. Okay? So, you're not going to get refunds on your supplemental or your 2023 tax years if you file your homeowner's exemption on parent-child exclusion right now. But you'll get that exemption going forward. Also, you have to file the parent-child exclusion claim form. The exclusion claim form must be filed within 3 years. If you don't file it within 3 years, it becomes prospective also. So let's say you move in within 1 year and you file your homeowner's exemption within 1 year, but you don't file your parent-child exclusion until today. Parents died in 2022. You will, because you filed your homeowner's exemption, because you moved into the property, you'll get refunds on your supplemental, you'll get refunds on your 2023 tax bill, and you'll get refunds on your 2024 tax bill. But if you wait till 2026, you'll only be prospective. So that's what the differences are. Number one rule, a child must move into the house within 1 year, otherwise you will not qualify at all, ever. Think about a property that might be in probate. Probate takes anywhere from 1.5 to 2 years. In some instances, the trustee will not allow anybody to move into the house. The child does not move in. They will not qualify. So that's why you really want to have a trust. You want to avoid probate.
What is the 1 year base from what
The 1 year what?
the child having to move in within 1 year? What date is that based on?
Based on the date of death of the parent.
Of the,
Or the transfer from the parent. Because you can do a parent-child exclusion while you're alive too. You know, the parents can always gift it or sell the property to their children, and it could get a parent-child exclusion. There's, as long as it was the parent's primary residence and the child moves in. So those qualifications, and you have that 1 year to move in.
say if the child happens to live in the property already,
Mhm.
and the parents already have filed the homeowner's exemption, do they have to, can they work out that file exemption by the parents, or do they have to file their own?
In order to be a homeowner's exemption, you have to be on title. So if the child's not on title, they can't file a homeowner's exemption. But if the parents die or gift it to the children, then the children have to file the homeowner's exemption within 1 year.
Okay, so they have to file.
Yes. Okay?
So, anything you said, I understand the property child exemption, as this value form only applies for principal residence,
Principal residence only.
not for investment properties.
No what?
Not for investment properties.
No investment properties at all. Parent-child exclusion does not apply to any investment property at all anymore. Whereas pre-Prop 19, like I said, you can get up to $1 million of other assessed property excluded from reassessment. Now, the other thing about the parent-child exclusion, see, I lost a little bit of track here. We were talking about, where was I going to go with it? Oh, the parents can go ahead and sell their property to their children while they're alive and qualify for the parent-child exclusion. There's no limit to the number of primary residences that a parent can transfer to children and get the parent-child exclusion. What does that mean? Just as an example for you, you own 4 properties, let's say,
Different counties,
yeah, in different counties. So let's assume for a moment somebody owns 4 houses. One is their primary residence and they have 4 children. So they sell or gift one property to their child, and it's their primary residence. The child gets the parent-child exclusion. Then they move to another one of their houses that they had been using as a rental for a long time. They established that as their primary residence. They register to vote. They file the homeowner's exemption. They get that base value, and they can gift that to a second child. And once they do that, that child can go ahead and get the parent-child exclusion also, as long as they move in within 1 year and file the homeowner's exemption and the claim form. Then they can move to their third property and do it all over again.
Is there a minimum requirement that the child has to live in that property?
Ah, okay. Well, let's start with a different answer or question first. Is there a minimum amount of time that the parents must live there to make it their primary residence? The answer is no. They can move, as long as they move in, establish it as their primary residence, and let's say they fill out their homeowner's exemption, register to vote, get the utilities in their name, insurance in their name, blah, blah, blah. Then decide, I don't want to live here anymore a week later, and move to another one of their houses. There's no requirement as to how long it has to be their primary residence as long as they establish it as a primary residence. The children, though, once they move in and qualify for the parent-child exclusion, if they move out, they lose the exclusion.
I'm not a tax person, I'm not an attorney.
Neither am I.
So just to clarify, but when they give the house while the parent is still alive and they do that, don't they have other tax consequences instead of the inheritance tax they wait until they pass away, they don't have to pay that? Isn't there some repercussions doing it that way?
Potentially they do, and that's why I always have a disclaimer on everything I do in writing saying this only deals with property tax issues. What I talk about is property tax issues only. If you're worried about capital gains tax, if you're worried about the IRS, if you're worried about any other issue, you need to talk to your attorney or tax rep. Okay? So I don't deal with the IRS at all. I deal strictly with the assessor's offices and California property tax issues. Okay? But you were talking about children moving out, or I was talking about children moving out. They lose the exclusion. Now, here's the thing. People are confused about the exclusions. The maximum exclusion right now, okay, when the law first passed, Prop 19, it was $1 million. It gets adjusted every other year. Every February of years ending in an odd number, they adjust it based on 1 year's worth of real estate data. So right now, beginning in 2023, instead of $1 million, the exemption is now $1,022,600. It's going to be adjusted again in 2025, okay? I don't know why they chose 1 year, but they did. And I don't know why they chose every other year, but for our purposes, just to keep things simple, I'm just going to call it $1 million. So when the child moves in, the assessor is, or when the parent dies or sells to their children, the assessor is required to reassess the property at fair market value. Then, once you apply for the parent-child exclusion, the child moves in, they qualify, they will get a maximum reduction in the new base value of $1 million. Example, let's say the parent's house is assessed at $300,000. Market value is $900,000. The maximum exclusion is $1 million, or what the previous assessed value was to your parents. So the difference between $900,000 and $300,000 is $600,000. So you're going to get a $600,000 reduction. Okay? But that $900,000 becomes your base value. So if you move out, you're required to notify the assessor that you no longer live in the house, so they can remove that exclusion. If you don't notify them and they discover it later, they can go back up to 8 years to collect back taxes on that $600,000 difference because you did not inform them. And I'll go into that in a second also. Oh, you have another question?
Okay, what if child A moves out? You have other children, can it be substituted by another child?
As long as the child's on Title II.
Oh, they have to be entitled?
Yeah, they have to be an owner. Okay?
So as long as they're entitled.
Because when they inherit the property, if, let's say you have 3 kids and all 3 of them stay on title, any one of the 3 kids can live there and qualify. Yes. But let's say you have one of the kids afterwards decide that they don't want to own the property anymore, so the 2 kids remaining buy out that 3rd kid. There's a 33% reassessment as of that date, and they take away 1/3 of the exclusion.
But, again, if I go back to my question, joint tenancy carries the right of survivorship, so it doesn't matter if a parent died or both parents died, the property would resort to the.
Okay. You really want to talk about joint tenancies, don't you?
It makes sense.
And you want to talk about trust also. Okay, you said you have joint tenancy and trust. Okay.
And that's why I'm concerned.
Okay. When did you create that trust, and when did you create the joint tenancy?
Since, in 08.
'08. Okay. So here's the thing about joint tenancy and trusts. Currently, if you have a trust, you can create a joint tenancy. If you create a joint tenancy and you have a trust, it's not allowable. It's not a true joint tenancy. If you do it now, however, from 2003, around November or October, through 2013, about the same month, you could have created a trust and have that trust part of a joint tenancy, and it would have qualified. But after 2013, they changed the law. So it's only that 10-year window, which you're in, that it qualifies for the joint tenancy. But a joint tenancy is very screwy from an assessment standpoint as far as the laws. I have attorneys that call me all the time with joint tenancy questions. I'm going to give you an example. What's your name? Armando. Marcus. Chris. Armando. Marcus. Chris. Armando owns a house. And he decides to add Marcus and Chris to title, all as joint tenants. Yeah, you're all happy about that. But the provision is you have to wipe his ass when he gets really old and can't do it himself. Okay, you're still good. Okay. So here's the situation. Okay. He goes ahead and he owns his house and he transfers the property from Armando to Armando, Marcus, and Chris, all as joint tenants. He's called an original transferor. He is what's called abbreviated OT. They are other than original transferors. OT, OT. OT? OT, 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 OT. Okay? Not reassessable when he creates that joint tenancy. If Marcus decides they all own the property equally, 33%, 33%, 33%. Marcus, 5 years later, decides, you know what? I'm going to put my 33% into a trust. When he does that, it severs the joint tenancy.
That would be tenancy common.
No, it's a joint tenancy. Well, he would sever.
Make that a tenancy common.
He would be severing the joint tenancy, and yes, it's now treated like a tenants in common because he severed it. Now they're going to reassess 66%, the 33% that each of them own. Okay, by severing that joint tenancy. Now, in your instance, you had a trust and you added all four of your children to each property?
Yes, sir.
So, in his case, let's assume they don't do that trust, it's just joint tenancies, and then Armando goes ahead and passes away. It's now the two OTOTs left, 100% reassessable, because there's no original transferor on title. You are the original transferor through your trust with your children. Upon your death, the joint tenancy ends and is 100% reassessable. Left him speechless.
Well, it's a lot to consider.
Yeah.
I gotta speak to my attorneys because I take good money.
Yeah.
For that.
Did you get my card?
Yes, sir, I do.
Okay.
I have both your cards, Mr. Meyer.
Uh-huh. Yeah. If he has questions, he can contact me. Because he'll have a lot of questions. But yeah, I charge attorneys for my time to explain joint tenancies to them. I'll do an hour class online with them and charge them for my time. And the lawyers are happy to pay me.
The only one that escapes the reassessment is the community property with
A spouse?
survivorship.
Yeah, community property will not be reassessed upon the death of either spouse or a divorce. How many of you are divorced? Okay. How many of you are planning on getting divorced? Okay, there's two ways to make money in this world. One, never get married, or two, never get divorced. Okay. One or the other. That's my opinion. So I've had to deal with a lot of people that got divorced and had young children. And I had to tell them, there's nothing I can do for you. Here's what happens. The husband and wife get divorced. They own a house. Sometimes they'll go ahead and they'll sell the house and split the proceeds. They're done. But sometimes they have children. Children that are anywhere from 3 years old all the way up to 15 years old. And there will be a clause in their divorce decree saying that one of the parents will remain in the house until the child reaches a certain age, at which time they will sell the house and split the proceeds. 5 years goes by, 10 years goes by, 15 years go by, and the child finally reaches that specific age, and the spouse that's living in the house decides they want to keep the house. So they tell their spouse, I'm going to buy you out. 50% reassessment. Because it's not an interspousal transfer anymore, because they got divorced. But if they put in their divorce decree the simple language of must sell the home and split the proceeds, or either could buy the other out, because it's part of the divorce decree, regardless of how old that divorce decree is, non-reassessable. Because it will still be considered interspousal. Yeah, little things that you can learn from me.
Would a prenup suffice on that too?
A prenup? It depends on if somebody goes on title or not. You know, it depends on how it's worded. Usually, yeah, a prenup, because it's part of the divorce decree. The properties get split up based on the prenup, and it's interspousal. Okay? Same thing with owning legal entities, interspousal. There's another way to avoid reassessment also. It's a co-tenancy exclusion. A co-tenancy exclusion is very particular. First, there can only be 2 people on title. Both people have to live in the property for at least 1 year. Both people have to be on title for at least 1 year. And one of the co-tenants has to die. Yeah. This was actually a law that was written, I think, 2012 or 13. It was written because of what was then called Proposition 8, the same-sex marriage issues, and couples. And I'm seeing a lot of my age who are cohabitating and not getting married, and they'll buy a house together. And I've met people that have never gotten married but have been living together and commingling their funds for 30 plus years. So a couple gets together, buy a house together, they're both on title, they live there for 30 years, and one of them passes away. Because they're both on title, they were both living in the house for at least 1 year prior to the death, and it ended by death, it's non-reassessable. I just sent a letter to the Board of Equalization last week, wanting an answer on this co-tenancy issue. Because the co-tenancy law specifically states, provided no other applicable exclusion applies. So what does that mean? That means, okay, interspousal is already covered. In 2013, the parent-child exclusion was already covered. But the parent-child exclusion didn't require the child to live there or be on title. Co-tenancy does. I have a client, I've had several clients actually, but one right now in LA County. The child was added to title 1 year and a week before dad died. And he'd been living with dad for about 3 or 4 years because dad was sick. Dad dies. It's more than a year that they've been on title, more than a year they've been living together. They qualify for the co-tenancy exclusion unless you're in LA. I was told that it's going to be denied because they were father and son and they have to apply for the parent-child exclusion. I said, no, they don't. They have to apply for it if they want it. They don't want that. They want the co-tenancy exclusion because then they're not reassessed. As I explained, when parents die, their property is reassessed. Under the co-tenancy exclusion, no reassessment at all.
It's very common, especially
I can't hear you.
It's very common, especially with the lenders, that they're asking to have a co-signer.
Okay.
Okay, let's say I bought this property with my brothers, and after 6 months, my brother, they decide that, they purchase their own home. So at this point, even like, they are not, making a payment, because I only use their income to qualify.
Right. So, can everybody do this? I want to see everybody do this once. Everybody, okay. All right. How many of you have sold a house or represented a buyer or seller where the buyers needed a cosigner to qualify? A lot of you. Oftentimes it's the parents that are the cosigners, correct? And sometimes the lender requires that the parents go on title. I did not know until Prop 19 passed how often the parent-child exclusion had been abused by the assessor's office. What that meant was, pre-Prop 19, parents would co-sign, they'd come off title 3 to 5 years later, and they would file the parent-child exclusion, no reassessment. Well, it's not the parent's primary residence, it's the kid's primary residence. So now it doesn't qualify for the parent-child exclusion. You have to go for the cosigner exclusion, which you will not find anywhere. So I'm advising people, hey, if you're going to get somebody to cosign for your client and they have to go on title, you start with a cosigner's agreement. I created one. I can help you with it. It's something that's listed in the Revenue and Taxation Code and property tax rules. And there's actually something on your, everybody know what a preliminary change of ownership report is?
Yeah, the deed.
Okay. Well, yeah, it goes with the deed. It goes to the recorder's office. The recorder's office does nothing except hand it to the assessor. And it has all those yes and no boxes on there. When you're working with a typical sale, the title company takes that P cord and they just draw a line right through all the no's. Okay? But each one of those yeses, if you mark any yes whatsoever, it's a potential exclusion from reassessment. So every time you check a yes box, the assessor looks at the P core and they look down the yes column. If there's a yes check, they go, uh-oh, red flag. We have to send out some forms and find out more information. There's one line in there that talks about change in title due to a cosigner. And it varies from county to county which number it is. But when you remove a cosigner from title, you should not be reassessed. Did that answer your question? Okay. But you have to prove it. Tax documents this thick, depending on how long you've had the cosigner on title. They want to prove where the funds came from. They want to prove, that the cosigner was not declaring interest deductions. They want to prove that the cosigner was not paying the property taxes. The cosigner was not depreciating the property. So they want to see both people's property income taxes.
Question. So the property was purchased, let's say, in 01. And then
It was purchased what?
Purchased in 2001 by an individual, right?
Okay.
Person. And then 10 years later, I get added to title, right? I get added, she still remains. And let's say now, 10 years later, if I remove her from title, what happens to the taxes?
Okay, she bought it, they added you to title, and now she's coming off title.
Yeah,
Okay, why did she buy it?
those are primary residents,
Okay, then she added you to title as a tenant in common or as a joint tenant?
joint tenants.
Like I was explaining up here, she's the OT, you're the OT-OT. So when she comes off title, 100% reassessable.
Based on what date? On whenever.
Based on the date that she came off title.
Gotcha.
Yep. OTs, joint tenancies, one of the most complex issues for property tax purposes. Used to be, people would call me, even when I worked for the assessor's office and after, call me and say, hey, I have a joint tenancy question. I go, oh, God damn. Now it's like, yeah, bring it.
Sailors, 55 years or older.
I'm sorry.
When a sailor is 55 years or older, what position, I think 19 or 13?
It's 19.
Whatever he is. Okay, so they buy a house, they sell their principal residence, they buy a replacement property, principal residence. They forget to submit the replacement property exemption taxes, and they qualify for that. What happens if
Okay.
they file after 2 years? And they didn't do it when they sold and they.
Okay. So this is another Prop 19 question. It has to do with base value transfers of replacement properties. So this is for people that are over 55. If somebody over 55 sells their primary residence and buys a new primary residence, they can qualify for what's called the base value transfer. Pre-Prop 19, you had to do it from the county you lived in to the county you lived in, or you could transfer it to one of what they called the participating counties. There were only 9 of them: LA, Ventura, San Bernardino, Riverside, Orange, and a couple of them up in Northern California. Prop 60 was when you were moving from one place in the county to another place in the county. Prop 90 is when you're moving from one county to another.
And then they changed it.
Right. The restrictions were, as they still are, you had to be over 55. 2, old restriction. You could not buy a replacement property for more than 5% of what you sold your original property for within 1 year, or 10% within 2 years. If you went over that 5% or 10% in the first year or second year, you would not qualify at all. And you could do it one time in a lifetime, period. New rules. You can buy, let's say you sell your property for $700,000 and you buy your replacement property for 1.1, and your old assessment is $200,000. So you can go ahead and transfer your base value plus the difference between what you sold the property for and bought the new property for. So you sell for $700,000, you buy for $1.1 million, $400,000 difference, that gets added to your $200,000. So your assessment is now $600,000 on your new property, okay? So you can buy a property more than 10% over what you sold your original property for. Also, new rule, any county, all counties I should say, are required to participate, okay? So I'll give you an example in a second why a lot of counties did not participate. If you sell your home, as an example, for $1.1 million, and you buy a replacement for $400,000, that's vacant land in most places, and you're assessed at $300,000. You transfer that base value to the new property, you have what's called a construction credit. The difference between your sales price, $1.1 million, your purchase price, $400,000, you have a $700,000 construction credit. So let's make something a little bit simpler and more realistic. Let's say you sell for 1.1 and you buy for 900. You have a $200,000 construction credit that you have to complete within 2 years of the sale, where you can do an addition or an accessory dwelling unit or a swimming pool. And as long as the value of that new construction is not more than $200,000, you don't get any additional assessment. It's not considered new construction. It's considered construction credit. I want to go back to another question you asked me about filing times. Okay, so you have, from the time you sell your primary residence, you have 2 years to buy your replacement property. If you do not buy your replacement property within 2 years, you will not qualify for this base value transfer, period. If you sell your property and buy the replacement within 2 years, you have 3 years to file the claim form, and you will get refunds all the way back to when you bought the property. But you have 3 years. If you miss that 3-year deadline, then it becomes prospective. So as long as you hit that 2-year window and qualify, you can file that base value transfer anytime in the future, but it becomes prospective, so you won't get refunds on any of the past years, but you'll get your reduction going forward. Okay? So let's go back to that construction credit and why a lot of counties did not participate in this Prop 90 program. That construction credit, imagine if somebody up in Bel Air sold their home for $10 million and they bought some vacant land for $1 million in Siskiyou County. Everybody know where Siskiyou is? Everybody goes there on a regular basis? Yeah. Tiny little thing, there's like 80 people in Siskiyou County. And you buy $1 million lot in Siskiyou. $1 million lot in Siskiyou is probably 100 acres, maybe more. You have a $9 million construction credit. What can you build for $9 million? and keep your old base value. That's why a lot of the counties would not participate. So that's a huge tax savings.
Then when they sell, the seller sells, this is 54.
Say that again?
When the seller sells the house, the principal residence, he's 54 and buys a principal residence, it doesn't qualify, it has to be 55.
They have to be 55, either them or their spouse. The other big difference is this. As I said, it was once in a lifetime. Now you can do it up to 3 times per person. So if you're married, you got 3 times. I mean, 6 times. So, yeah. Yeah. So, yeah, that's another big benefit of the Prop 19 base value transfer.
Going on the sale price, is that the actual sales price, or are you taking into account adjusted sales price, that's closing costs?
It's the actual consideration to the seller.
Okay, so it's a sales price.
Yeah.
Do smart homes or
Speak up.
container homes? Do smart homes or container homes pay property taxes?
I'm sorry?
Smart homes?
A smart home? What's a smart home?
Container homes.
A container home. I don't know what a smart home or a container home is. What is that?
This is something that is brand new that is coming to the market. I guess it started back in Canada. So they call them a smart homes and or container homes. Do they pay property taxes?
When you say container home, I'm thinking about the back of a truck, dropping it on the ground and living in it.
Yeah, they make them.
Is that what it is?
Yeah, they put them on top.
Okay. Okay. Is it on a permanent foundation? Are they putting them on permanent foundations?
Yes, they are.
It becomes real property. If it's not on a permanent foundation, it's considered personal property, and personal property is assessable unless it's your own, unless there's an exclusion that applies. For instance, at a bank, everything is personal property, accessible as business personal property, except the vault door and security systems. I don't know why, but when a bank closes and relocates, they take the door with them. I don't know why, but like these tables right here are considered personal property. They're accessible because it's to a business. The business owns it, not an individual as household furnishings. Your household furnishings are exempt from taxation. On your personal lot, you might have like a little, what do you call those? When you go to Home Depot and you buy those 12 by 12 sheds and put them in your backyard, they're not on a permanent foundation, so they're not accessible. A container would not be accessible if it's not on a foundation, but once you put it on a permanent foundation, it could become accessible. So that's going to be addressed later. It's like a mobile home. A mobile home, if it's on a permanent foundation, it's accessible by the assessor's office. If it's not, it's taxed by the DMV.
Prop 5. They're trying to chip away at.
Is this the new proposition?
Yeah.
I haven't read it yet.
Oh, no, on Prop 5. They're trying to chip away at Prop 13. They're trying to take it away. I mean, little by little, they're chipping away at things. So I just wanted to give you a
Yeah. Now, I know there's a lot of initiatives on the ballot. Like I said, every 3 years or so, they throw something on there to try to hurt Prop 13, which they did with the Prop 19 as far as the parent-child exclusion portion. They brought in some good things with the base value transfer situation, but they hurt the parent-child exclusion. I've got a lot of questions.
For a remodel, if I'm gonna tear down the whole property and keep one wall, does it get fully reassessed or part?
Tear down the structure except for one wall and not be reassessed. That is an old myth. I don't know where it came from. Okay. There is a section.
As you continue to answer these questions, I got to raffle 3 Starbucks cards. So if you want to put or participate in the raffle, I'll come by.
Okay. New construction includes demolition. So if you demolish a house, the assessor is supposed to remove that from the roll. And then when you build the new house, they add that to the roll. There's a clause in the Revenue and Taxation Code that says that if you do a remodel, reconstruction, and you take it down to studs, it's the equivalent of new. And they can reassess you for that. It depends on what you're doing. You know, if you're actually doing a complete redesign of the house, they could reassess you or partially reassess you. But typically they don't if you're doing just a typical remodel, even if you take it to studs. But it depends on what extent you do. You can't hear me? Well, that's because you guys were talking. No, she asked me about the one wall rule. I don't know where that started. It's laughable. Somebody started a rumor decades and decades before I ever worked for the assessor that if you leave one wall, it's not reassessable. That's not true. If you take the property down to studs, it's considered equivalent to new and you could be reassessed. So you have a question. You raised your hand 3 times.
Regarding that Prop 19 and parents that do own multiple properties, is there any way around putting in properties in
If it's an
LLC or something?
Okay, it only applies to primary residence, but you were talking, if you did what?
Like, gentlemen, if you own 3 or 4 properties, and you're trying to avoid that reassessment for your kids, that thing is putting properties in LLC. Is there any?
Okay. There is a trick that used to get used all the time. It was an LLC transfer, where you transfer the property into an LLC, and then you transfer up to 50% to your children, then take it out of the LLC, do a small transfer to children, put it into a new LLC. When you transfer, you own where do you go? Okay, the guy that owned other properties. If you own investment property, shopping center, a strip mall, a small, like a fourplex or something, okay, and you transfer the property into an LLC. Let's say it's you and your spouse, or you hold title in your trust. It's called a proportional transfer. You transfer property into an LLC, and as long as the member of the LLC is in the exact same proportion ownership and the exact same people or trust that own the property, it's non-reassessable. But the assessor is going to want to look at documents. But over time, if cumulatively more than 50% transfers, it's 100% reassessable upon that change in ownership. Change in control versus change of ownership for legal entities. Change in control applies to all legal entities that own property. If any individual who does not currently have more than 50% interest acquires more than 50% interest, and I'm talking 1 iota. You know, show me with your hands how big an iota is. Okay. Yeah. So if somebody gains control, let's say they have 50%, they do not have control, but if they have 50% plus an iota, they now have control. All LLCs or legal entities, legal entity being LLC, partnership, or corporation, if they own property and there's a change in control of the entity, the property that they own in California is 100% reassessable. It must be reported to the state within 90 days. Failure to report to the state within 90 days creates a 10% penalty of that year's tax. The whole tax, not just the amount that it increases. That sounds like a lot, but it's really not that much, because let's say you got $1 million tax bill, it's a $100,000 penalty. But if you have a $30,000 tax bill, it's a $3,000 penalty. So it's just for 1 year. But when you do the proportional interest transfer, there's an additional requirement. It's called the cumulative rule. Cumulative rule is over time, if more than 50% of the membership interest of a legal entity changes hands that qualify for the proportional interest transfer, then once you go past the 50% cumulative, it's 100% reassessable, has to be reported to the state within 90 days, and if you don't report, you got that tax. So I'll give you the example. We've used you guys before, so I'm going to use you guys again. So we've got Armando, Marcus, and Chris. They go ahead and they own property. Let's say they own a little strip mall. It's worth $2 million. They decide they're going to transfer it into a legal entity. They create this legal entity where each one of them is 1/3 owner. They transfer the property to the legal entity. It's proportional, no reassessment. 20 years later, it's now worth $10 million. Armando gives his interest to his children. How many kids you got? That's what you know about, right? Okay. So he transfers his 33% equally to his 3 children. So his children are each 11%. These guys are still 33%. You don't get along with your wife very well, so you guys get divorced, but she gets your 33% interest. Interspousal does not count toward the cumulative. Okay? So now we got Chris, we got Marcus's wife, because Marcus is out of the picture, and Armando's kids. Cumulatively, 33% has transferred. Wife decides she doesn't want to participate anymore. So she takes her 33% and sells half of it to Chris and half to your children. We're now at 66% cumulative. 100% reassessable, must be reported to the state. Okay? So that is your proportional transfer to the LLC issue. You got to be aware of it. A lot of CPAs don't know about that. Some attorneys don't know about it. I know about it. So I warn people about it all the time.
When you reference the state, you refer to the county assessor.
I work for the assessor, yes.
Right now, when you were referring to the state, have you reported to the state?
No, you report it to the state. You report it to the Board of Equalization on a specific form. It's a BOE 90. So you report it to the state within 90 days. The state informs the county that you're in. The county goes ahead and reassesses the property. In LA County, you're looking at 4 years later. It takes the state 2 years to record this stuff. But here's the differences. I'm going to give you some statute of limitation issues. Statute of limitations. Let's assume for a moment you do some new construction or you buy property, you record a deed, you get a permit, either one of those. The assessor is made aware of it, either through the recorder's office or through the jurisdiction that issued the permit. For some reason, the assessor missed it. They missed the deed. They missed the permit. I've seen a lot of missed permits. Working against LA County, I see it all the time. 20 years later, it's discovered. The assessor is required to reassess the property or the new construction as of the date of change in ownership or the completion of the new construction, even if it happened 20 years ago. But the statute of limitations, because you actually took out a permit and they were notified, because you recorded a deed and they were notified. How many of you have done new construction before? You have 2 sets of plans, right? You go down to building and safety, you hand them 2 sets of plans. Building and safety takes 1 set of plans and puts it on their desk, and then they send the other one over to the assessor's office. That's why you put in 2 sets of plans, because the assessor is required to get 1 set by law. So the assessor missed it. They still have to go back 20 years when they, even though they discover it this year, they have to go 20 years to when it actually occurred, figure out what the value was for that year, do all the factoring for all the intervening years, but they can only collect 4 years worth of back taxes. So the county can only go back 4 years if it's their mistake. If, however, you went out and built a 8,000 square foot house without a permit, because everybody does that, or you did a land contract with somebody but didn't record it, or a deed with somebody, so you bought somebody's house but you didn't record the deed, and it was 20 years ago, and then the assessor discovers it for some reason, they go back that 20 years, and the county will send you 8 years worth of tax bills. So 8-year statute of limitations on collections. Legal entities. If there is a change in ownership on the proportional interest transfers or a change in control of any LLC and you don't report it to the state, happened 20 years ago, you get 20 years worth of tax bills. No statute of limitations on how far back you can go. Pardon me? If you have a legal entity that underwent a change of ownership or change in control and you failed to report it to the state, there's no statute of limitations on how far back the assessor can go, or I say assessor, but it's actually the county can go to collect back taxes. The assessor does not collect taxes. They do not issue tax bills. The auditor issues the tax bills, the tax collector collects the tax bills. But there's no statute of limitation. Are we done?